The Supreme Court of the United States recently issued a ruling in Louisiana versus Cowley that struck down the state's congressional map. It also upended Black Louisianans' hard-won right to elect the candidates of their choice. That alone is devastating. But the court didn't stop there. In its ruling, this extremist 6-3 majority also eviscerated Section 2 of the Voting Rights Act of 1965. That's the only remaining statute that protects against racial discrimination in voting nationwide. The Voting Rights Act of 1965 was one of the final nails in the coffin of Jim Crow. But with this decision, the court has dealt a death blow to the VRA's promise to ensure that all voters of any background have representation in the halls of power at every level of government. It is now nearly impossible to challenge discrimination in congressional redistricting, but not only there, in state and local districting across the country. And the implications of this are massive. An analysis by Fair Fight Action and Black Voters Matter Fund said that this ruling could result in the loss of between 25 to 30% of the Congressional Black Caucus and up to 11% of the Congressional Hispanic Caucus. That would undo nearly 60 years of progress that produced some of the most diverse leadership in our country's history. Now, while the Supreme Court rendered its decision, it does not have the final say. That's up to us. Our votes matter now more than ever. We, the people, must use our collective power to demand better from our leaders, to bring this fight to the states and demand state and local level voting protections. We need to press Congress to enact new impenetrable voting rights legislation. So let's get to work.